morning. My name is Dora Leung. I am your MLS breakfast meeting program chair. But I want to share a little bit about something about myself and some story that you might not know. I got my real estate license when I was pregnant. And after 2 years, I got nothing to do, right? After 2 years, my California dream came true. I became a homeowner on an FHA loan with a foreclosure property. It's only $168,000. Can you believe today this house is worth close to a million? That's why we are here, work hard with the CAR to make sure that for better access for our home ownership. Is that right? Yes. Thank you. One thing I want to share with you my gratitude. I want to say thank you to WSGVR for the opportunity to keep us learning every day, almost every day new. I have a great time to serving for one of the board of directors and also our co-state political contact for state assembly member, standard form advisory committee members. I remember for my first commercial listing here, WSGR, we met my buyer broker and we closed the deals within 6 months. This was expired from a renowned broker. So from that on, I tell myself, I don't want to miss any participation and network event or experience in WSGR. So please stay with me for the rest of the month, August, on every Thursday, MLF breakfast meeting. This is the time that we wait for. Let's give a warm welcome to our guest speaker, attorney Kelly Richardson, but I have a little introduction about him. Kelly G. Richardson has been practicing law over 41 years. 41, can you believe? I calculate 17 and 18. And is a partner in Richardson Ober, based in Pasadena. He's a broker and also CAR member. Kelly is a legal counsel to 6 associations of realtors, including the Acadia Pasadena Foothill Association. Mr. Richardson is a longtime friend of WSGVR. Can you believe it? I just tell him that 10 years ago, I have his notes on the risk management. So thank you for him coming back. And for many years, he has received the title super lawyer in the field of real estate law. He has for 19 years written a weekly column. I love People Journals, appearing throughout Southern California on HOA laws. He is also a graduate of USC Law Center. Let's give him a round of applause, please. Kelly Richardson.
Well, so nice to be with all of you. I'm going to watch the clock closely because Belen said, Kelly, you have to be done by noon. I will be done in about 30, 35 minutes, okay? And I want to say, talking about age and time, you know whose fault it is that I'm here. In fact, who's started me on what ultimately was my real estate law career was Buck Stapleton, who... And you all, because he invited me to come to this board when you over on Palm Avenue, wasn't it, Buck? Yeah, Palm Avenue, and speak, I think, about construction defects or something like that. And I enjoyed it so much that led to joining Legal Affairs Forum, and then I got my license and started working with PFAR. And I'm very thankful to people. You know, you never know, your encouragement may start somebody's entire career. So I never get tired of thanking my friend for that. And I also noticed as I was waiting here to come on and enjoying your introductions and pitches and such, I saw the 100th anniversary certificate for this association from 2 years ago. And I thought to myself, I had no idea Albert was that old. So, you know, God bless him. He looks great, doesn't he? So, all right. So this morning, this is a topic that I'm very passionate about. And the reason why I'm passionate about it is because I started out as a lawyer because I wanted to fight for people in court. That's why I got my license. That was my dream, to be in court and try to fight for people and businesses and get them justice. But after you fought a lot of lawsuits, and I have tried many, many cases. In fact, I was fortunate enough about 15 years ago to be received into an elite jury trial lawyers association. Most people don't know that. And I love fighting in court. But you know what? The more I see battles, and after 41 years of being in courtrooms, I am much more passionate now about trying to make sure my clients aren't in the courtroom. And that's really what this is about, okay? There are times when you wind up in court because you have no other choice. But I work really hard at this late stage in my career in trying to find every possible way and strategy that I can protect my clients and keep them out of the courtroom, because it's expensive and it's painful and it's risky. So yeah, I am super passionate about this topic today. And when we talk about conflict is not the same thing as disagreement, okay? Two very different things. Disagreement is simply when you are looking at the same thing, but you disagree. Now, I'm sure you haven't noticed this in our society in 2024, but there are a lot of things we all disagree about, right? From sports teams to political parties to stances on real estate issues, all right? But that isn't what I'm talking about as bad. Disagreement is fine, it's natural and to be expected. Conflict is what I'm against. And that's when we take that disagreement and it escalates into some type of unhealthy interaction. That is what I'm very much against. And that's what I want to talk about today is how can we avoid disagreements from turning into painful, destructive activity. So jumping into that, I mentioned a minute ago, lawsuits and conflict is expensive. If conflict is not managed properly, if disagreements are not handled wisely, it can really take the joy out of your career. I have had many clients in my office in real estate or other walks of life who've told me, you know what, this is just not fun anymore. Why am I even bothering to do this? The distraction of litigation is painful. It can also reduce your credibility. How many times have you all seen somebody get upset and say stupid, unwise things? And what happens to your confidence in that person when you see them behave that way, right? It drops, right? They lose respect. Well, we don't want to lose respect of our colleagues. So that's another reason why we want to control conflict. And conflict, when it gets out of control, can be extraordinarily expensive. I can't tell you how many times by the time a lawsuit is over, my client looks back over 2, 5, 7, one time 10 years of litigation up and down the Court of Appeals, and they've spent on each side more than $1 million. Yeah. So we don't want to take this lightly. We want to try to make sure it doesn't eat us up. And of course, one of the things that I find in my career, I spend a lot of time when somebody comes and talks to me and says, well, do I have a case? One of the things I tell them is not just do they have a case, but is the case worth pursuing? And it's not just a financial consideration. It's the distraction and stress, the negative energy that comes along with fighting and fighting and fighting and worrying about what they're going to try to do to you. There's an expense. And so I can't tell you how many times I talk to clients and I say, okay, are you up for this? And from time to time, people say, yes, you bet, let's go get them. And then about 9 months in, they feel differently. Why did I do this? Is this really worth it? So, and lastly, if conflict gets out of control, you can wind up in handcuffs, right? So we really want to make sure that we don't have we avoid these types of horrific consequences as much as possible. Now, you've all heard the parable of the elephant, haven't you? The ancient parable about I think it was 6 blind monks. They were all blind and they were all taken to an elephant. And each of them was put next to a different part of the elephant, one next to the elephant's leg, one next to the elephant's tail, one the trunk, one up on the elephant's back, one next to the body of the elephant. And each of the blind monks were asked to describe what they saw. And of course, the monk next to the tail said, well, this is a big snake, right? And the person on the side of the elephant said, oh, well, this is a big wall, and so on. And each of those monks had a dramatically different experience with what they knew to be true. Now, were any of them lying? Of course not. Were any of them wrong? Also, of course not. They had been experiencing a very different thing. And the other monks, in listening to each other, in today's society, what would they say? Oh, you're a liar. You don't know what you're talking about. You're making this up. So one of the things I want to start off with, a really, really critical concept, is you don't know what the other person in the transaction, what the other person in the negotiation or the dispute, even disputes in governance here in this association, you don't know what that other person knows and what they see and what's important to them. So I could stop right there. If we could really make this parable apply to our own lives, we would see conflict and we plummet, and we would see our wisdom and our empathy and our success with our colleagues skyrocket, because it's not just what I know and what I see. So that's really key. And in our society right now, I know none of you have noticed this, but everybody knows everything, right? And there's no other point of view possible. And Nancy, if you disagree with me, I'm just going to cut you off, right? I'm going to disconnect. Yeah, that's our society right now. And boy, that would be a whole nother seminar. Maybe some other time we'll talk about that. But my point is remember the elephant in your professional practice, in your family life, in your volunteer work. Remember, other people are seeing something different than you. I take testimony under oath from people all the time. And it's amazing how many times I'll have one person say, no, we never talked about that unpermitted addition. No, the realtor did not tell me. And the realtor says with equal confidence, absolutely. I spoke with them. I told them there was a problem with permits on the property, and they said no big deal. Now, who's lying? You know what? I find a lot of times neither is lying, because the truth is the client wasn't listening. And in their memory, they don't remember the conversation at all. Why? Because they were preoccupied. They were thinking about the swimming pool, or they were thinking about the next thing they had to do that day. You as a professional knew, super important issue. That's why you remember the conversation vividly, but your client wasn't paying attention. Nobody's lying, but you have two diametrically opposed testimonies. And that's something that I've seen after 41 years of lawsuits that I'm never cease to be amazed. And each side never for 1 minute, I'm sorry, culturally, we never assume that the other person is mistaken, or that they might think that was the truth. What do we always say? Liar. Well, it isn't necessarily always lying, okay? So remember the elephant, because a lot of times our clients are not paying attention to the very important things that you're telling them during the transaction. And that's why we lawyers beg you to put everything in writing. Send an email, send a letter, send a fax, send a text. Hey, client, just want to remind you, we talked today about that addition in the back that was not permitted. You might want to have a contractor look at it. Hey, I'm so glad to be your realtor. Boom. Okay. So we put things in writing, because our client may not be paying attention to the part of the elephant that we're trying to tell them is reality. So when we're dealing with a disagreement, instead of immediately thinking about all the reasons they're wrong, what about trying to figure out, what do they know that I don't know? Because we've all been around real estate long enough to know that it's a pretty good comparison to an elephant, with all the different aspects of a property, particularly residential or commercial. So think about their point of view, think about what might be important to them, and that will also help you be much more strategic and successful in your negotiation, won't it? I win lots of negotiations by simply figuring out, from listening to the other side and reading between the lines, what is this really all about? Is it strictly about money? or is there something else? Is it about time, or is it something else? So listen to the other side. You're going to find yourself much more successful in your negotiations, but also you're going to find yourself a little bit less likely to jump to hostile and negative conclusions. When you're dealing with a disagreement, watch out for your opening assumptions. Now, this very week, I talked to a homeowners association president, not in the San Gabriel Valley, who told me with great emphasis, Kelly, this neighbor, they're just evil. They're just evil. That's it. They're evil. And I'm going to send you the emails, Kelly, where he called me a liar, said I was incompetent, questioned my integrity, and other abusive things. I said, okay, send me. Guy's name is Steve. Steve, send me those emails. So he sent me the emails within the hour. I read the emails. Do you know not one of them said, Steve, you're lying to us. Steve, you're not a very good HOA president. They were asking questions about expenses and some repairs that they were requesting. There were no insults anywhere. But that's what this person had decided, that anything that comes out of this person's mouth is evil because they're the devil. So it's not fair to assume, even people that are hostile to you, it's not businesslike, it's not wise to assume that they're a devil any more than you would assume that the person on the other side of the discussion or negotiation or disagreement is an angel and that everything they say is true and must be obeyed. We don't do that. So let's be even-handed with folks. Let's remember that everybody's got, at our church, some of us are fond of saying, everybody's got stuff. We've all got stuff. Nobody's house is completely clean. So give people a chance, all right? Watch out for those initial assumptions. So now I want to talk a little bit about tips for conflict prevention. Now, actually, we've already talked about some underlying attitudes that affect our likelihood to be in conflict and unhealthy disagreements. Here's one of the first things I suggest to clients. Take a breath. Take a breath. There might be some more information that's coming out if you'll allow it to. When we immediately jump to react, and by the way, you may have read, a lot of our sociologists have said that a real common trait in our society is that when you're in conversation, you are not completely listening to what the other person is saying, because at some point while you're listening, you're already thinking about what you're going to say next, which means you stop listening to the person that was speaking. So that's just something that we all, guilty, we all have to fight and be aware of. So slow down, give people a chance, let them get it all out. What's their thing? You might find that in the course of somebody venting and telling you all their problems, you may find that somewhere in there toward the end, they start mentioning, roof leak. Uh-oh, wait a minute, roof leak, that's a concern. What about the roof leak? Okay. And all the other stuff was just kind of leading up to that. They were venting all their feelings and their unhappiness, but there really is something there that if you take enough time to listen. So ask questions. Before you make statements, take a few moments and ask questions. Help me understand why you feel this way. Help me understand. Tell me more. What do you know about this issue? Tell me why you feel this way. Now, again, culturally, we're so anxious to tell the other side why they're wrong or why we're right that we cut off the opportunity to learn information that may help us tactically, not only in reduce conflict, but may help us understand what they're coming from in a negotiating aspect. So ask questions, ask questions, ask questions, ask questions. Why should we ask questions, Kelly? Exactly. Ask questions, okay? All right. Educate the other side. Now, this is a huge problem in homeowner association governance, huge. And frankly, in associations of realtors, a lot of nonprofit groups. Sometimes people are upset with you or what you're doing because of stuff they just don't know. So I always urge people, assume the other person doesn't know. Don't always assume they know something and they know what they're saying is specifically wrong or dishonest. Start with the assumption that they're decent folk trying to do the best for their client. And let them prove to you that it's something other than that. But start out by the assumption that they don't know stuff. And so instead of a fighter, Take the posture of an educator. Help them understand why this is important to your client. Hey, I know you want this personal warranty on the house, but my clients didn't live there. It was actually lived in by their children for a while. They don't even know the condition of the property. So they can't possibly warrant the condition of the house. Or my clients retire, whatever the answer might be. But sometimes you need to explain to the other side what they don't know. So if you take the response of a listener and then an educator, you may find that you've diffused something before it ever gets close to a flat out conflict where you wind up calling me. And of course, you know it, walk a mile, right? In their moccasins. Empathy, try to understand what's important to them and don't disregard it. They may have an unrealistic expectation, but try to figure out, okay, how can I respond to that? How can I not disrespect what they're feeling, what they're saying? Okay, that's good old-fashioned empathy. That will help prevent conflict as well. And lastly, and this I got from Judge, oh gosh, what was his name? I'll think of it. A judge in Peter, I forgot his last name, a judge that was in the Central Civil West Courthouse in downtown Los Angeles. He handled major, what they called long cause trials. And I had a very, very contentious case in front of him. And we were in his chambers and he was trying to have settlement conversations between the other side and I. And this was potentially a $1 million, multi-million-dollar issue. And at one point, the judge asked me about a particular issue. And I got up ahead of steam and I did what we often tend to do as lawyers, started, telling him all the reasons why the other side was wrong. And he stopped me. And the judge said, Mr. Richardson, is this the hill you want to die on? Because you can only die on one hill. So there's only one issue in any deal that can be the hill. Once you've been on that hill, either you're dead or you win. So pick your battles is what the judge said. And I've always remembered that advice. The other thing that's really, really hard, realtors and affiliates, is could you be the problem? Is your ego, your emotions, your desire to preserve your, respect, are you the one escalating? Now, let's be honest. I know sometimes if I'm not careful, I can overreact to a situation. I can respond with too much energy. And sometimes I'm actually the one escalating. And so I would suggest that you know yourself. Listen to what's coming out of your mouth. Ask yourself, why am I getting upset about this? Now, particularly in real estate and law, we have a lot of similarities between us because we're representing other people. It's not my money. It's not my property. I'm just giving advice and relating my client's position, right? And so one of the things that we give our clients is the unbiased, expert, unemotional analysis of transactions or of disputes in court. That's what we do. We're kind of buffers. So sometimes we have to remember, hey, who am I? And separate ourselves as people of worth from that particular transaction. You know what? That transaction may have worked out poorly. That doesn't mean I'm a bad person. It doesn't mean that I'm not valuable as a professional, okay? And when you step away with your own self-worth from your professional day-to-day work, okay, you're going to find yourself with a much healthier attitude. Not that you don't care, but that you recognize, hey, some deals work out great, some don't. Sometimes their surprise is good, sometimes their surprise is bad. You know what? We do the best we can. But if we can take our ego out of the transaction, we're going to be less likely to flash and develop conflict. When people are upset, find the kernel. Another reason why you want to listen for a while, like in that leaky roof situation, is sometimes it takes people a few minutes to sort of get it out of their system. Now, I meet with lots and lots of your clients. Now, most real estate buyers and sellers don't consult lawyers like me. We all know that. It's, if you look statistically, it's very rare. But the people that do come to see me, one of the things I've gotten used to is I tell people right up front, I said, my consultations are an hour and a quarter. I don't offer 30 minutes or 15 minutes, an hour and a quarter. You know why? Because most of the time it takes 15 minutes for the client to kind of start telling their story. And before I get a chance to do any analysis or give advice. So let people talk and listen. And after a few minutes, you'll start hearing what's really going on. So don't respond to the emotion. Don't respond to the energy. I hate to say it, but don't respond to the curse words or insults. Okay. Listen for factually what's going on. And you're going to do much better in not escalating that conversation. So listen for the kernel. Why are they upset? They may be expressing their upset in an unhealthy way. So ignore the expression and go to the fact. What's the problem? Oh, you have a leaky roof and you're upset. Or you found some mold in your garage and you're scared because the damnable mold industry has frightened you with all that toxic mold baloney. Okay, whatever it is, listen for that kernel and you'll be able to do better. And you're going to have to listen. You're going to have to lend your ear, be more willing to listen than to speak. One of the wisest people that I know and the wisest people that we see in movies, what is one of the hallmarks of really, really wise people? They listen. They wait for it all to come out, and they're not quite that anxious to answer immediately. So lend your ear, let them talk. And history. Oh, Kelly, you don't know this particular realtor. I've known him for 25 years, and this is every single transaction. This is how they operate. Okay, forget about history. Take each situation on its own. We lawyers have the same problem. Yeah, there's hundreds of thousands of lawyers in Los Angeles. I don't know them all. But you know what? There are certain lawyers that I keep seeing in the San Gabriel Valley. And I know, oh my God, that one, I'll never forget what that lawyer did to me. But you know what? That doesn't necessarily mean I'm going to have the same experience today in 2024. So I'm preaching to myself here too. So forget about the past, take the now, take the present, and again, give people a chance to prove that they're unreasonable before you assume they're unreasonable. And don't be too quick. Don't be too quick to pull the legal trigger. Your clients think that the very first reaction when people are upset is, I'm going to sue. I'm going to have a lawyer call you. I'm going to take you to court. And it's a very cheap threat. But a lot of times people will find lawyers who will take their money to write a threatening letter or to do something like that. Don't be so quick to get lawyers involved out front. A little trick of the trade. I have found the longer I do this, the more I ghostwrite letters for my clients. I don't need to be the big guy and write on my letterhead. My job is to help. And sometimes the best way I can help is by helping my client write a letter and that the other side doesn't even know counsel's involved. Yeah, that's really powerful. So I do a lot of that these days. I typically look for opportunities to say to the client, can I write this for you? And let's see if this works. I can always jump in later. So don't be too quick on the legal trigger. Why? Because of Richardson's rule of ratcheting. Richardson's rule of ratcheting is basically this. It's super easy to ratchet. You know what a ratchet is, right? Those are those wrenches that go, but they don't go the other way, right? They lock up. Okay, well, that's exactly what escalating disputes is like. It is so easy to go from 0 to 90 miles an hour. It's so easy to go from 72 comfortable degrees to 110. Boom. Okay. But once you're up at that really intense conflict level, it is extraordinarily hard to de-escalate that conflict. It's much easier to maintain or escalate than it is to de-escalate. So remember that when you take a step to increase the level of hostility, you're not going to be able to take it back. Right? You've broken a barrier. You can't unbreak it. So that's why I say to clients, okay, are you sure you need to file a lawsuit? Is there anything else we can do? Before we escalate to the ultimate hostility, which is a lawsuit, let's try to see if we can find other things to do. And certainly, I discourage your clients from immediately going from I have a disagreement to I want to take them to court. We try to find ways to get around that. Another thing, I get a lot of calls, from realtors. I volunteer on the legal hotline. When the legal hotline, as you may have called them, they're wonderful folks at CR. There's a whole group of attorneys, like a dozen of them, and they literally all day long have a headset and they sit in a cubicle and they answer your calls, and they ask you the property address and the name of the other party, and they put it into a very sophisticated computer software. That's because if the other side of the transaction calls, then CR's legal hotline, right? Because they've already advised one side. So they formed this, I think they call it the referral panel, of a bunch of us volunteer real estate attorneys across the state. And we agree basically, well, we'll go ahead and take that second call for free. We'll give them 15 minutes, 20 minutes, help them as best we can. So I get a ton of these calls. And probably one of the most common calls that I get is fights over deposits when a deal has gone south. And a lot of times I'm telling the realtor, hey, ask your client what's more important to them. They really want to keep that $11,000? They might have a right to it. But if the buyer's not willing to just let it go and is threatening litigation, is this really that important? I mean, you're selling $1.5 million property. You had 2 or 3 backup offers. Why muck all this up with a dispute over $11,000? So sometimes I find myself asking the realtor to encourage their client not to give legal advice to them, but is this really the most important thing to you? And a lot of times what's most important to the seller is we just want to sell the property. I mean, it'd be nice to keep the deposit, but you know what? That's kind of a bonus. Okay. So a lot of times our clients need perspective. Now, I think giving them perspective on the economics is not legal advice. You're just talking business with them. You don't have to tell them about the merits or lack of merits of the seller's effort to hang on to the deposit. So I think perspective, putting things in a more business-like point of view, as opposed to the principle of the thing, I think sometimes will save your clients a ton of money. And again, Peter Lichtman, that was the judge's name. You've always got to remind your clients and yourself, is this the hill you want to die on? Because you can only do it once. So pick your battles. When I leave you today, I'm going to be going into a post-mediation call with a woman who owns hundreds of thousands of acres. I won't say where. And there is a dispute between her and her 2 other siblings about the disposition of this property. And there are all kinds of issues. There's issues about appraisal. There's issues about reimbursements. There's issues about who's going to sell the land, blah, 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 blah. Okay. And one of the things that I'm fighting with this particular client, who's a dear, dear person, is perspective. Is this, if you don't get this, are you willing to go to court and potentially spend hundreds of thousands of dollars and 2 to 5 years of your life in litigation? Sometimes we have to. Sometimes we're up against the wall and we have no choice. But most of the time we have a choice. So is that the hill you want to die on? I think most of the time it's not. So as I wrap up, let's say the conflict is escalated. You've done everything you can, but doggone it, we're still now having legal threats exchanged. Well, there's three main ways, of which really 2 are the most common in settling disputes. Mediation, far and away, is the most common. Now, you all know the RPA requires mediation, or you're going to blow your right to attorney's fees. So we are forcing you to offer mediation, and if the other side offers mediation, to accept and participate in mediation. Mediation is not a trial. Mediation is simply a conversation between the 2 sides that is facilitated by the mediator. The mediator is like the diplomat that goes back and forth between Russia and Ukraine. And they aren't all in the same room. They kill each other. So the mediator goes back and forth and says, okay, well, if you agree to stop dropping bombs on this, let me see if I can get them to stop dropping bombs on that. That's what the mediator does. Now, you don't have to settle. All you have to do is have the interaction through the mediator. So the mediator doesn't decide who's right or who's wrong. The mediator just wants everybody to stop fighting. And sometimes that means that the settlement is a 50-50 split. Sometimes it's a 90-10 split. The mediator really doesn't care because their enemy is not your client or the other client. Their enemy is the lawsuit. So that's what they're trying to do. If mediation fails, another way to stay out of court is arbitration. I'm working with a real estate broker right now, an agent who happens to be a broker as well. His former broker cheated him bad. He's refusing to pay him a really large commission on a piece of property. And so my client is looking at his options. And so what he's doing is he's taking his claim to arbitration through his particular board, not the association. And so he's going to be doing arbitration. Arbitration is when you have somebody who you both sides agree will decide who's right and who's wrong. And they make a decision, and then that decision is binding. There's also a neutral evaluation. That's really rare, but that's when you hire an independent third party who's hopefully expert, who says, all right, I'm going to look at everybody's arguments, and then I'm going to write up a decision that's not binding on anybody, but just so you know, I'm going to tell everybody where they're strong and where they're weak. So if you guys want to keep fighting, okay, but maybe you want to think about it before you do that. So if conflict management fails, you're not just going to spend money. You're going to have professional and personal relationships ruptured. You're going to spend a lot of money in attorney's fees, and your client and possibly you are going to be very distracted for a time. If you're successful in managing conflict, you're not going to have litigation. You're going to have somebody like me just write up the contract. Yay. Much more fun to write up deals than to tear them apart and put them in court, right? And you'll be able to focus on success and the next deal. And you're going to enjoy your practice all the more. Now, your clients aren't always going to be completely pleased, but they're going to be much more happy with a non-litigation outcome 90 times out of 100 than they will if they go to litigation. I have a case right now. I got a text as I was driving here from a client who I took a case to trial in the Torrance courthouse. We won. The other side, who's kind of a crook, appealed, lost on appeal. We got more attorney's fees. And my client is just determined she's going to get her money, but it's been a really long road for her. And it's taken quite a toll on her emotionally. So, we want to avoid that if we can. And so be more successful, slow down, do what we can to avoid the conflict. When the conflict does get legal, though, as soon as a lawyer intervenes with an email or a letter, a phone call, your first response should be, well, my broker's attorney is, thank you very much. I'm not going to be able to talk to you anymore. Okay. Get your lawyer involved. So thank you for listening. Be successful and enjoy your practice. And I look forward to coming back hopefully again. Thank you.
Please join us our next week as we welcome another attorney focusing on property tax reassessment, Attorney Jonathan Westphania from West Coast Property Tax Appeal.